Welcome to Open Campus, Pacific Northwest Tax School's online learning management system. Open Campus is the platform we use to deliver course content and materials to you. Open Campus allows you to access course content, complete course assignments, review grades, access the Q&A forum, and when all required assignments are completed, Open Campus will allow you to print your certificate of completion. The course lecture will begin momentarily, but first we will take a few moments to describe the tasks you must complete to successfully complete this course. Look to the green status bar at the top of your screen to see your progress throughout the course. Click on the link inside the status bar to move on to the next step. If you have not already done so, please go to the Materials page and print the manual for this course. You must watch all course videos in their entirety to receive credit for this course. You can pause or replay this video using the drag bar located at the bottom of the video. Passwords are included in each video. Write the passwords down. When you have finished watching all course videos, you will be ready to complete course assignments. The first course assignment is the password test. You must receive a score of 100% to pass the password test. You must also complete the classwork, quiz, and homework assignments for this course. The passing score for these assignments is 70%. Use the Q&A forum to post questions and receive answers from our staff about topics included in this course or to receive technical support. All right, then welcome to our final course in the Welcome to Oregon series. In today's class, we're going to be looking at Oregon ethics, and we're also going to be looking at strategies for passing the Oregon LTP and LTC exams. And the strategy for passing the exams is, of course, well, just know what the law is. That's the first strategy. But there are some other strategies aside from sheer knowledge that I'll be covering with you today. But we are going to begin with the licensing law itself. And also, although I call the course Oregon Ethics, when you get down into the meat of it, ethics is a combination of knowing the law as it applies to tax consultants and tax preparers in the state of Oregon, but also understanding the code of conduct under which all practicing licensed preparers are supposed to be operating. And so the manual begins at the bottom of page 1, where we give you a little bit of a summary, which by now I'm sure you're well aware of, which is that Oregon is the only state that requires an individual who prepares a personal income tax return for a fee to pass a state-administered examination, possess a license, and maintain his or her knowledge by attending 30 hours of continuing education per year. Now, there are a couple of other states that actually do have registration requirements. The state of New York requires all tax preparers to register and pay a $100 fee every year, but they don't have any testing requirement, no knowledge requirement. You just have to be registered and pay your fee. The state of Maryland also has a registration process and an examination requirement. However, they've been sitting in limbo since their law came into effect in 2008. Whereby they were saying they were just waiting to see what the IRS was going to do, and then they said if you pass the IRS test, it's good enough for Maryland, and now who knows what Maryland's doing. And then we've got California, our neighbor to the south, who has the most strict standards in the state next to Oregon. And their standards are that you have to take an approved course that's been approved by the California Tax Education Council. It has to cover 45 hours of federal law, 15 hours of California law. The school has to administer an exam of its own. You have to pay for and receive a bond from the state of California in the amount of $5,000. But there's no statewide exam. And once you have your registration permit in California, you're required to have 20 hours of CPE a year. So to just compare Oregon to all of that, our standards are so much higher than any other state. I don't want to ever say that we're perfect because we are far from it. I think it could be much more rigorous what we have here. However, where we sit, we are the most rigorous state and have been the most rigorous state since 1973 when the licensing laws first came into effect. So we are literally in our 40th year of Oregon licensing for tax preparers. Now, the rules for professional conduct of tax practitioners in Oregon are straightforward and should be one of the easier portions of the LTC and the LTP exams for an individual to pass. However, you should not discount the importance of this session. And the reason is that if you haven't read the law and at least familiarized yourself with it, you're just going to miss easy points on the test. So let's take a look at what the basics of it are. And we're going to begin with tax preparer qualifications. And by that we mean, what does it take to become a tax preparer in the state of Oregon? Firstly, you have to be at least 18 years old if you wish to take the Oregon LTP exam and obtain a license. You must have a high school diploma or a GED equivalency. You must present to the board a session attendance certificate form that is signed by your school instructor, which shows you successfully completed at least 80 hours in basic income tax law, theory, and practice at a school that has been approved by the board. You should submit proof of attendance with your license application after you successfully pass the exam. You submit copies of official transcripts and course summaries for college courses with your application in lieu of completing an 80-hour course. However, acceptance of these alternative tax-related courses will be at the discretion of the board. And essentially what that means is, let's just suppose you want to hire in your practice, or you already are an individual who have taken a series of tax-related courses at college level, university level, and you have enough hours of that type of education from where you've gone to school that you think that you shouldn't need to take an 80-hour course, that you should be able to substitute this college education in place of it. And the Oregon Tax Board says, yeah, they will consider that, but you would need to submit to them a listing of the courses that you completed and obviously something showing that you had completed them and the number of hours and so forth. And I know of a number of individuals who have successfully managed to do that. Also, you must pass an examination that is administered by the board. By the board, we mean the Oregon Board of Tax Practitioners, also called the Tax Board. In general lingo, we always refer to the Oregon Board of Tax Practitioners as the Tax Board here in Oregon, but throughout today's course, we'll just simply refer to it as the board. Now, when you take that exam, you really can take it as many times as you want. The board says not more than once per month, but that would be a little bit difficult to contemplate anyway. As often as you need, you can go take that test. However, every time you take that test, you're going to be out some money because there are fees for registering to take the test, and there are also Proctor fees that you must pay every time you take the test. Now, there is a rule, a fairly recent rule that the board has implemented, which says if you have not passed the test within 3 years of completing the basic tax course that you have taken, then you must retake another basic tax course. Now, one of the motivations behind that is not just someone who's tried and failed to take the test and then tried and failed again, but just individuals who take the course and then go a number of years before they even attempt to take the test, and then maybe they kind of just try and brush up a bit and then take the test. And the board is saying, no, 3 years is enough time. If you haven't passed it in that time frame, you're out of luck. So those are the requirements for becoming a preparer, and they're relatively straightforward. Take an 80-hour course, have a high school diploma, be 18 or older. Pay your fee, go take the test. If you pass the test with a score of 75% or higher, then you can get a license. For becoming an LTC, there are more rules, more stringent rules, and these first rules that I'm looking at are qualifications for a person who is already licensed as a licensed tax preparer, who then wishes to become a licensed tax consultant. Firstly, the additional qualifications are that you have to submit evidence on a verification of work experience form that is signed by your employer or employers that verifies that you have worked as a licensed tax preparer for a minimum of 1,100 hours during at least 2 out of the last 5 years. There is a provision that allows you to substitute up to 212 hours of experience working as a volunteer, but only if you volunteered at tax preparation programs such as VITA or AARP, and then these hours must be verified by your volunteer supervisor. You may substitute education credits in lieu of up to 365 hours of the 1,100 hours of required experience at a rate of 1 classroom hour for each 5 hours of experience, provided that the subject matter was related to taxation and you completed the course within 1 year before applying to become an LTC. And then you obviously can't use that same hours used to qualify for work experience to turn around and qualify for CPE experience for license renewal. The board also will accept employment as an income tax auditor or taxpayer service representative with the IRS or the State Department of Revenue as being the equivalent of work experience. In addition, an LTP who wishes to take the LTC exam must have a minimum of 15 hours of acceptable continuing education in personal income tax law that has been completed within a year prior to submitting an application for taking the exam. And finally, of course, there's the exam itself that must be passed with a score of 75% or higher. Becoming an LTC if you are not licensed in Oregon as an LTP. In general, the tax board requires that you complete the LTP education, that is, take the 80-hour basic tax course, and then you also have to complete the LTP exam and take apprenticeship, getting that 1,100 hours of work experience. So that's what they generally want to see. But the board does have rules that provide for a person to become an LTC, even if you are not already an LTP, if the following requirements are met. Firstly, you submit evidence that you have completed at least 80 hours of basic tax education. Prior experience credit may be granted for up to 53 hours, but you must have completed at least 27 additional verifiable classroom hours on top of that. You must have been actively engaged in tax preparation within 2 years of the application. You must have at least 3 years of tax preparation experience, and you must provide verification from employers or evidence of self-employment. You submit the verification of work experience form, and it needs to be signed by your employer and verify that there is at least 1,100 hours of work experience in at least 2 out of the last 5 years. You can use the hours of employment as an income tax auditor or taxpayer service representative with the IRS or the Oregon Department of Revenue again towards fulfillment of that 1,100 hours of work experience. You may substitute volunteer experience in lieu of up to 212 hours at a ratio of 1 hour for each 5 hours worked as a volunteer. And again, that has to be verified. You may substitute education credits in lieu of up to 365 hours out of the 1,100 hours at a rate of 1 classroom hour for each 5 hours of experience, provided the subject matter is related to taxation, you completed the course within a year before applying to become an LTC, and you do not claim the same course credits to fulfill continuing education requirements. Also, you have to submit evidence of completing that 15 hours of CPE within a year of taking the test, and you must pass the tax consultant test itself with a score of 75% or higher. The next one we look at is that out-of-state experience, but you don't have an employer because you were self-employed. So you've been working as a tax preparer in some other state, Washington, California, pretty much anywhere except Oregon, and it's been legal for you to do so under the laws of that state, so you're not in violation of Oregon's law by working in Oregon without being licensed, right? So you've worked in another state which doesn't have licensing, and you've got this work experience. You want to bring it here and use it to take the LTC exam. And the way the tax board words it, they say, if you have worked as a tax consultant outside of the state of Oregon, the board may accept your application to sit the LTC exam if you meet the following requirements. Submit the evidence that you have completed at least 80 hours of basic tax education, but prior credit can be granted for up to 53 classroom hours, but you must have completed at least 27 additional verifiable classroom hours. You have to submit proof of tax preparation experience on a self-employment petition form along with the supporting documentation. For example, Schedule C, a business bank account, business registration, or Form 1099, something that shows or proves that you really have been working as a self-employed person in another state and that you can show you have 1,100 hours of work experience working in that self-employed occupation as a tax preparer in another state. And it has to be within 2 out of the last 5 years. You may submit volunteer experience in lieu of up to 212 of those 1,100 hours working for VITA or AARP, and the experience will be allowed at a ratio of 1 hour for each 5 hours worked as a volunteer. You may submit education credits in lieu of 365 of the 1,100 hours of required experience of a ratio of 1 classroom hour for each 5 hours of experience, provided the subject matter, again, is related to taxation, you complete the course within a year, and you do not claim the same credits for CPE. And then finally, you still have to get that 15 hours of CPE within 1 year of taking the exam. Now, until recently, the board allowed an individual who was an enrolled agent to sit the LTC exam based on the enrolled agent credential only. The board then became concerned that tax professionals with no experience were skirting apprenticeship and education requirements, thus exposing the public to incompetent LTCs. And it was a very common strategy. Lots of people I knew maybe worked 1 season as a tax preparer, would pass the enrolled agent exam, and by their 2nd season they were working as LTCs, only having to pass that Oregon portion of the test. I even had an individual apply for a job with me once who had no work experience of any kind. He had simply studied for, passed the enrolled agent exam, and so he was an enrolled agent with 0 work experience. And Oregon is saying that's just not going to fly anymore in Oregon. You have to be able to show you've got some work experience. So if you want to become an LTC based on your enrolled agent credential, board rules now require you to meet the following requirements. You must submit a copy of your valid EA or enrolled agent card, both front and back, and no other document will be accepted as a substitute for the enrollment card. You must obtain a minimum of 360 hours of work experience within at least 2 out of the last 5 years. You must complete either the verification of work experience form that is signed by your employer or employers, or the self-employment petition form. If your work experience has been obtained outside of Oregon from self-employment, you must provide the board with supporting documentation, again, that essentially proves you really did work as a self-employed person. And then finally, you need to pass the Oregon tax law and Oregon income tax service law and code of professional conduct portions of the LTC exam with a score of 75% or higher. Now, one of the things I've heard over the years, or basically been told to me many times over the years, is that lots of people who have managed to go and pass that enrolled agent exam come along and take the Oregon portion of the Oregon exam and flunk it. So you can't really underestimate the importance of getting a good handle on Oregon law and not assume that it's just kind of a shoe-in thing because you've been able to pass the enrolled agent exam. All right, so we're going to move on to take a look at the Oregon Income Tax Service Law next. And there's really kind of 2 parts to the law. The one is the actual Oregon Revised Statutes, or ORS. That's the law that works its way through the Oregon legislature. So back in 1973, Oregon Revised Statutes were passed by our legislature, creating tax preparer laws in Oregon. And among the things that was done by that tax preparer law was the call for the formation of a board of tax practitioners. And the tax practitioners, the board of tax practitioners, their job is to look at the law, interpret the law, and create systems and policies, procedures, rules under which all tax preparers in this state will operate. So there's the basic law, which isn't very long, and then there are the procedures that have been created by the tax board, which are actually fairly lengthy to read through. So Oregon Income Tax Service Law is contained in the Oregon Revised Statutes, and the law provides definitions, licensing requirements for businesses, tax consultants, and preparers, and the establishment of an Oregon State Board of Tax Practitioners, which consists of 7 board members who are appointed by the governor and confirmed by the Senate. It also outlines the authorities and responsibilities of the tax board. And so when you see ORS followed by a number, in this case 673.610, this is actually Oregon Revised Statute. This is the section it would be referring to. And I've gone in and basically pulled out some key points from that section or from ORS and inserted them into our manual. But reading the manual is not a substitute for actually reading the code. So you should still go and read the code in its entirety, because all I've done is pulled out what I think is the most relevant. But we're going to begin with applicability. And applicability is about who is governed by the law. And it actually kind of works backwards by saying that the law does not apply to an employee who prepares income taxes for the business of his or her employer only, or an attorney at law rendering services in the performance of the duties of an attorney at law, a fiduciary acting on behalf of the fiduciary estate, the testator, trustor, grantor, or beneficiaries thereof, a certified public accountant holding a valid permit issued by any state, public accountant holding a valid permit issued under ORS 673-100, or a public accounting firm registered in any state. In addition, the law does not apply to any employee of this group. Any person employed by a local, state, or federal government agency, but only in the performance of official duties. So that is who is not covered by the law, and essentially if you're not listed as not covered, then technically you are covered. That's kind of how it works. And then we move on to prohibited acts, things that you are not allowed to do. And except as otherwise provided, a person may not prepare or advise or assist in the preparation of personal income tax returns for another and for valuable consideration, or represent that the person is so engaged unless that person is licensed as a tax consultant. So Oregon law says that in order to prepare tax returns, unless you're exempt from the law in that first section, you have to be licensed as a consultant. And you have to be licensed for any form of consideration you are receiving in the performance of preparation of a return or advising or consulting on a return. And the way you'd read this is it's saying, well, I can't do it at all unless I'm a consultant. But then it goes on to say a tax preparer may prepare or assist in the preparation of tax returns only if they are under the supervision of a tax consultant or a person who is described above and is subject to such conditions and limitations as the State Board of Tax Practitioners by rule may impose. So what that's essentially saying is that in order to practice in Oregon as a tax preparer, unless you're exempt, you must be a tax consultant. And the only way around that provision is if you are a preparer, but even then only if you were under the supervision of a consultant. So essentially every preparer in the state must work for someone who is exempt from the licensing laws like a CPA or must work for an LTC. And I should point out that under Oregon law, enrolled agents do not receive special treatment. For example, in California, if you are an enrolled agent, you are not governed by other rules affecting tax preparers in California. And at the federal level, if you are an enrolled agent, you're not required to pass the RTRP exam if they ever bring that back. But Oregon couldn't care less if you're an enrolled agent. You don't get special privileges for being one, other than you don't have to have as many hours of work experience and you only have to take the Oregon portion of the exam. That's all they really give you for being an EA, and an EA in and of itself does not exempt you from other laws that govern tax preparers in Oregon. Also, a person may not be the facilitator of a refund anticipation loan without first being issued a license as a consultant or a tax preparer. The next section we go on to is disciplinary action and grounds. The board may refuse to issue or renew licenses, suspend licenses, or reprimand a licensee for a variety of reasons, including prohibited actions involving the illegal use of licenses, failure to keep required records, gross negligence or incompetence in the preparation of tax returns, felony conviction for a crime that has elements of dishonesty, fraud, or deception, failure to comply with the continuing education requirements, failure to be current on personal income tax filings and or payments with the Oregon Department of Revenue. So if you're behind on your own taxes, you haven't filed your own tax returns where you're required to do so, then that's cause to have your license revoked. Violation of the Code of Professional Conduct, failure to pay any civil penalty properly imposed by the board, cancellation, revocation, or refusal to renew by any federal or state agency the authority to practice as a CPA, EA, attorney, or other practice under regulatory law if the action is a result of misconduct or actions by the licensee and they were related to income tax preparation or involve dishonesty, fraud, or deception. Prohibited acts. It is unlawful for any person to obtain or attempt to obtain a license as a tax consultant or as a tax preparer by any fraudulent representation, or represent that the person is licensed as a consultant or a preparer if that person is not so licensed, or to present or attempt to use the license of another person, or attempt to use a suspended, lapsed, or revoked license, or to falsely impersonate a licensee, or to engage in dishonesty, fraud, deception relating to the preparation of personal income tax returns, or to violate any position of trust, including a position of trust outside that licensee's professional practice. So essentially what the board is saying is if you have violated trust outside your area of practice, then you're probably not to be trusted with a license, because more than likely your character, your basic nature is going to make you a risk in terms of probably violating the trust of your clients. Moving on, we also have some provisions regarding refund anticipation loan disclosures. And I actually emailed the Oregon Tax Board saying, you know, the IRS has essentially outlawed RALs, maybe a need to take a look at this. And so actually they are taking a look at it. We might see some revisions of this in the future. But for now, there still are provisions in the code that you could be tested on relating to refund anticipation loans. So refund anticipation loan is a means by which a person borrows money against their refund in anticipation that their refund will be used to then pay it off. And the IRS effectively, as of the 2013 season, has banned RALs. You can't get them anymore. However, there are a few companies who have skirted around some of the interstate banking rules and found local lenders to still fund these. So in that respect, it might still be possible to run across a firm that is offering them. And if it happens to be you, then you need to know that anytime you give a loan based on a refund to a client, you have to disclose all costs associated with that RAL. You have to tell the client that the RAL is a loan, that a RAL will not speed up the delivery time for receiving a refund, and also that there's no guarantee that the IRS will actually deliver the refund necessary to pay off the loan. And if the loan doesn't get paid off, then they will be liable for repaying the bank that made the loan. Civil penalties, the board can levy civil penalties of up to $5,000 for each violation. It can also prescribe completion of an educational program as a remedy. I can tell you that the Oregon board, they get all kinds of people that they're investigating on a regular basis, and they dish out some pretty heavy fines on a regular basis. You shouldn't ever for 1 second believe that you're going to get away with cheating the system for very long. You might pull it off for a few weeks of the tax season. You might even pull it off for 1 or 2 tax seasons in their entirety. But eventually at some point, the board's going to start sniffing you out, and they're going to send out an investigator. And when they do, it could be very, very expensive. So it's best to not play the game. And I'm thinking of one of the most recent situations where the board handed out a pretty hefty fine. Was a firm acquired a new location on the Oregon coast, and it was through a franchised company. I'm not sure if it was Jackson Hewitt Liberty, one of those major national chains. The franchise owner applied for a consultant waiver to open up an office on the coast of Oregon, and the waiver was denied. And so they operated anyway. Well, they got nailed and shut down, and lots of fines, and I don't know any more details than that right off of hand, but it's all public record, and you can go into the Oregon Tax Board website to read about people who have been cited and fined and the story behind it. So it's not worth playing those games. Now, moving on to the Oregon Administrative Rules. The Oregon Administrative Rules are the rules that the board itself creates based on the authority they're provided under the law. And as I explained at the start, the Oregon Tax Board is made up of 7 individuals. 6 of those individuals are tax professionals, LTCs, who've basically passed ethics and background checks and who've been involved in the tax preparation business for a long enough period of time that it is deemed that they have the knowledge and background necessary to sit on the board. But the board also has one position that is basically a member-at-large position, someone who is not involved in the tax preparation industry at all. And that at-large member sits on the board to basically offer the perspective, you could say, of the taxpayer rather than the tax practitioner. And so those people who sit on the board, they look at the law and they decide, well, this thing's working not good enough, let's change it. And so they'll propose changes amongst themselves, and then they'll vote on it. And if they vote on it and it passes, then the law can actually change. And so over time, since I've been in this business over 20 years, I've seen the Oregon Tax Board change lots of its rules over time. But for now, we're going to show you what the rules are as they've been released in the latest version of the Oregon Administrative Rules. And we'll be going through those, and of course I'll show you where you can go on the Oregon Board website to read them in their entirety on your own. And in fact, why don't I just do that right now? If you've never been to the website of the Oregon Tax Board, you really should get in the habit of going there, just kind of seeing what's going on. And right now, you can go down to this link right here. It says links to related sites. And if you go in there, Then you see we've got Oregon associations that you can link to if you are curious about learning about the Oregon Association of Tax Consultants or the Oregon Society of Tax Consultants or the Oregon Society of Enrolled Agents. There's links to their sites. But then you go into that and it says legal resources. And you can see the Oregon Revised Statutes. That was what I was explaining is the law. And then underneath that is the Oregon Administrative Rules, which is technically also the law. And it's divided up into a number of divisions, they're called. You can see there's Division 1, Procedural Rules, Division 10, Code of Conduct, Division 15, Education, Division 20, Procedures, Division 25, Tax Preparation Business, and Division 30, Miscellaneous. So that's what I'm going to be talking about now during our course. We'll be taking a look at those together. And just going back into the forms page, I've mentioned that there are a number of forms that you need to fill out if you're doing this or that, and those forms can be found on the Oregon Forms page. Also, you can find information about the examination process on the examination page, and in there you will also find the general information booklet that is updated each year on September 1st. Now, I'll be showing you that booklet in a little bit, but this is where you go to get your own copy of it. And you can know that for the 2013 year, which we're in now, there will only be one sitting of the Oregon Tax Preparer and Tax Consultant exams that you would actually go to the tax board itself to take that test. And that test would be December 7th, 2013. And this is where it is and what time it starts at Chemeketa College or Community College in Salem. Now, if you can't make that date, and it's understandable that might be difficult for you, then what you do is you can take the test at Proctor sites. And information about the various Proctor sites is inside the examination booklet. And again, we'll get into that in a little bit. So I showed you where you can go to get the Oregon Administrative Rules, and I showed you all of those divisions. And I'm going to be going through those divisions, but not in the same order that you saw them on their website. I've kind of put them more in an order that seems of importance to me, you could say, things that you really need to know that I think are important to your conduct and activities as a tax practitioner within the state. So we'll just go up to the bottom of page 7 here where it says the Oregon State Board of Tax Practitioners formulates the Oregon Administrative Rules, which detail procedural rules, the Code of Professional Conduct requirements, education requirements, procedures for obtaining and reviewing licenses, including the associated fees, tax preparation business requirements, and miscellaneous rules, including civil penalties. Well, we're going to start really with what I think it's all about anyway, which is the operation of a tax preparation business. Whether you are an employee or the owner of a business, you should really understand what the law requires that business to do to maintain proper ethical standings and not be outside of the law. Firstly, the business itself has to be registered. A tax preparation business must register annually with the board, and the business must comply with applicable laws and rules of the Oregon Corporation Division. It has to pay a registration fee and report the authorized individual or individuals who are responsible for the tax preparation activities and decisions of the business. A person who operates a tax preparation business under more than one name is required to register each name as a separate business. A new business registration must be submitted to the board within 15 days of a change in name or ownership. And I just wanted to point out that 15 is a magic number. If you are sitting the Oregon exam and it asks you for a period of time in which you have to inform the board of something, it's usually 15 days. It's not always 15, but they actually did go out of their way to try and make 15 the constant. So again, if you do get a question about the number of days you have and you default to 15, you're probably right. Reporting the closing of a business, address, or phone number change. A tax preparation business shall notify the board again within 15 days of termination of the tax preparation business or a change in the mailing address, physical address, email address, or the telephone number or numbers of the tax preparation business. Renewal of the tax preparation business registration. Tax preparation business registrations expire annually on June 15, except the combination of a tax preparation business registration that is combined with a tax preparer license. If that's the case, then it would expire on October 15th. So Oregon law says that in order to run a business in Oregon, that business has to be licensed. And in order for that business to be licensed, it has to have a designated consultant. Well, consultant licenses expire at the end of May. And so in most cases, a business registration is going to be combined with the renewal of a LTC license. So the LTC will renew at the end of May, and then the choice can be made to renew the business registration and the LTC registration all at the same time. And then that's due by the 15th of June. But it is possible for a business to be owned by someone who is not an LTC. That would be a person possibly who is an LTP. And if it's an LTP who owns the business, then they can renew that business registration within 15 days of the expiration of the preparer license. So you kind of have that grace window there, and that's where that falls. In fact, when I first got into the business of tax preparation, I wasn't licensed as a preparer or a consultant. I simply bought a franchise. And then I hired a consultant to work for me, and I got my business license under the license of that consultant. So it is possible to own a business in Oregon without actually being licensed yourself. However, it's fairly unusual and not really in the best financial interest of the business owner to not have their own license. So you can imagine I quickly got on that and got my license as fast as I possibly could. Renewal registration shall be issued to a qualifying tax preparation business upon receipt of a completed registration, renewal application, and payment of a fee to register that business. And there's also a note up here that at least 30 calendar days prior to expiration of registration, the board will notify the tax preparation business that they need to renew. And then, of course, the renewal registration has to be sent in. It has to have money sent with it in order for it to be valid. And tax preparation businesses whose registration has expired are not allowed to perform tax preparation services to the public for a fee or offer such services until that business submits a new tax preparation business registration application and that application has been accepted and processed. Displaying business registration, a tax preparation business shall post their current registration in public view in their place of business. And I can tell you that if the tax board is going to do an investigation of a business, the way that they do that is they walk in the front door of the business, and the first thing they look for is the license on the wall. No license on the wall in public view, it's automatic justification for a fine. So that placement of the license in public view not only applies to the business itself, its business registration must be in public view, but the license of each individual working in that business must also be in view. So if you are working as a licensed individual for another employer, that employer needs to have their license on the wall in public view, and they need to have your license on the wall in public view. So what I see a lot of tax professionals do is they just carry their license with them and they put it on their desk in front of them when they're at work to make sure that legal requirement is met. Branch offices. So branch office, you might have your main office that's licensed, but you could have, in addition to that main office, you could have one or two or more additional offices, and those are referred to as branch offices. A tax preparation business shall not operate any branch office until the tax preparation business has complied with all laws and rules of the board concerning tax business registration. The mailing address, physical address, email, and phone number of the branch office and the name and license number of the resident consultant for that branch office must be submitted to the board, and the tax preparation business must pay the annual fee for the branch office registration as is required under the Oregon Administrative Rules. Branch office registrations shall expire annually on the same date of the associated tax business registration, and at least 30 calendar days before the expiration of the branch office registration, the board will attempt to notify the tax preparation business using contact information that has been provided to them by the business. So you obviously can't come up with the excuse, well, I never got the information in the mail because we moved, because the board's saying you have to tell us within 15 days that you moved, and therefore the excuse you moved so I never got the renewal application will never work. Renewal branch office registration shall be issued to qualifying tax preparation businesses upon receipt of the required annual registration fee and, of course, the application itself. A tax preparation business operating branch offices shall notify the board within 15 days of any change of address, email address, phone number, or a change in the resident consultant or designated consultant for that branch office or the actual closing of the office itself. Branch offices must be conducted under the same name as the principal office. This name and current registration shall be again posted in public view in each branch office. And the name of the designated consultant and the name of the resident consultant must be posted in public view in each branch office. So you're hearing these terms, resident consultant, designated consultant. What's the difference? Well, we're looking at designated consultant first, and every business must have a designated consultant. The designated consultant is the person at the top, the person who's ultimately responsible for all of the operations of that business. Their license number is associated with that business registration. The designated consultant does not need to be the owner of the business, but they are accepting very big liability because they are responsible for the operations of the business. And if you have a business that wants to hire you to be their designated consultant, that's a legal obligation that you have to make sure that the business itself is in compliance with the law. Because if the business operates outside of compliance with the law, your license is on the line. You can personally be fined. So every business has to have a designated consultant, and let's take a look at some of the additional rules around that. So business shall not prepare returns or offer income tax services to the public until it has a designated licensed tax consultant or other authorized individual designated consultant. The designated consultant shall be responsible for all tax preparation activities of the business and with the business's compliance with laws and rules of the board. The designated consultant will cease to be responsible for a business's tax preparation services upon receipt by the board of written notice from that consultant or the business. A licensed consultant may act as the designated consultant for only one tax preparation business, except by a written application for a waiver. So what that's saying is if someone hires you to be the designated consultant for their business, you can't work there part-time and then be the designated consultant for another business. They don't allow that. But they do have a provision for a waiver, and an application for a waiver to serve as a designated consultant for more than one tax preparation business can be submitted, and it could be considered. It doesn't mean that they'll accept it, but they will consider it. But that application for a waiver has to set forth the following information: the name and address of the tax preparation business for which the LTC is presently serving as designated consultant, the name and address of the additional tax preparation office that the tax consultant also wants to be the designated consultant over, a detailed plan showing how each tax preparation business will be supervised by that designated consultant. That's a lot of work to supervise two independent businesses. How are you going to do that? They want to know what your plan is for doing that. The financial relationship of the proposed designated consultant and the tax preparation businesses, and any unusual or extenuating circumstances which explain why approval should be granted by the board. In determining whether an LTC will be approved to act as a designated consultant for more than one business, the board may approve an application for a waiver only wherein the LTC has ownership interest in the tax preparation businesses or unusual or extenuating circumstances exist, such as the death of a designated consultant resulting in undue hardship. The board may limit the LTC consultant designation period and shall consider the LTC's past record of compliance with all of the Oregon administrative rules and whether or not they've basically behaved well in the past. A tax preparation business shall notify the board within 15 days of any change in its status as a designated consultant. Management and supervision of the tax business. From my point of view, having worked in this business as long as I have and having supervised people as long as I have, the management and supervision of the tax preparation business is important for two very good reasons. Firstly, if you manage your business in compliance with the law, then in the end, you're going to deliver better quality to your clients. It's more money to do it this way. Certainly, you have to figure out how you're going to put all of the procedures and policies in place to be in compliance with the law. It's not that easy. And because it's not easy, I know for a fact that there's lots of businesses out there that operate outside of compliance with the law all the time and have done so for years. The dilemma around managing an office and doing so outside of the law and getting away with it is that the tax board really is quite limited in its resources. And when it goes into a business and it decides that it's going to investigate a business, it does what's easy and obvious. It looks for licenses on the wall. Getting into the meat of how a business has been operated and whether it's been operated within compliance with the law, that's harder. And the board can only really do an investigation into a business for failure to comply with the law if someone, basically an employee within that business, rats on it, the whistleblower. So it's not very often that you really see the board get into the meat of how a business is operated, but you should still consider that. Firstly, it is potentially possible that if you see the company that you're employed with is doing things very badly, and they are outside of the law, and you know that they're outside of the law, that is a risk for you. But secondly, if the business is not in compliance with the law, the quality of tax preparation services they're delivering is not going to be as good. So a lot of these rules are just good business practice. So in addition to being required under the law, it's smart to follow them under the law. That's kind of my summation of it. So here we go. Each principal and branch office must be under the management and supervision of a tax consultant. Supervision means the direct and immediate control of the LTP by the LTC in such a manner that the consultant is aware of the line of questioning and reasoning that is being employed by the tax preparer. The tax consultant must have adequate opportunity to correct or add to the reasoning of the tax preparer. Well, when you think about it, how is the consultant going to know what the preparer is saying? Seems to me that the consultant should be able to hear what the tax preparer is saying. You know, do you have a policy where you can see the preparer and hear the preparer as they're interviewing a client? Do you have procedures where they have to go through an interview? Have you trained them on the interview? What is it that you're doing to make sure that you have that immediate control over that tax preparer, to make sure they're doing things the way they should to be in compliance with your office procedures? Also, you should have a system of selecting, training, and controlling the preparer, including a set of procedures by which the consultant is assured that the preparer is providing competent workmanship and abiding by the statutes and board rules. Such procedures shall include reviewing all tax returns for errors, notifying a tax preparer of changes to tax returns made after review, maintaining current federal and state reference material in the principal and branch offices, providing access to the consultant for the tax preparer, including access by telephone or electronic media. Tax preparers with less than 240 hours and 1 year of tax preparation experience in the last 3 years may not work without direct on-site supervision of more experienced personnel when preparing, advising, or assisting in the preparation of tax returns. So what this is saying is you've got a preparer that you're responsible for as a consultant. You need to review all of the tax returns that that preparer prepares. You may not need to review them personally yourself, but you need to have someone else review them that you've trained who you feel is competent to do so. So you should never have a situation where a preparer prepares a return and that return gets filed and you have never looked at it. You're supposed to be looking at it. And you're supposed to be looking at it well enough that you probably find a few mistakes. And then you tell that preparer, hey, I found this mistake. You need to correct it. You need to do this further research. You need to know this stuff better. Now, what I have noticed and observed in Oregon is that this first 2 points right here, many businesses do not follow these 2 procedures up here. And if you have been unfortunate enough to gain your work experience in a firm that is not reviewing your work and not notifying you of the changes, well, there's 2 things happening. Firstly, that firm is outside of the law. You could report them for that. Secondly, you probably didn't learn very much apprenticing in that firm because it's not reviewing their work. They're not finding your mistakes. And I guarantee you, you've made mistakes. So if no one's ever told you you made a mistake, that means you've been probably doing something wrong over and over and over and over again and never even knew it. How common are mistakes? I make mistakes. I make them every season, and I make them more than once every season. Sometimes I make them embarrassingly often every season. It's such nitpicky work that it's really impossible to get it perfect every time. And so there's just the human error side. Even when you know what you're doing, you could get it wrong. But there's also the factual knowledge side of things, that there's some aspect of the tax law you just didn't really get. You've got filing status information wrong, or there's a federal tax credit available to an individual that you weren't aware of. And a more experienced person, by reviewing that return, might pick up on the fact that you didn't give someone a credit that they were entitled to. So those types of things are good for your knowledge and your growth. And if you're not working in a firm that's given you that, then you have to work 3, 4, 5, 10 times as hard on the study side of things to make up for that. All right, so moving on to some other stuff here. If a licensed tax preparer is found by the board to be in violation of the statutes or board rules, the LTC, who is responsible for the supervision of that preparer, shall be deemed to be in violation in the same manner and to the same extent, and may be disciplined by the board regardless of any discipline imposed on that preparer directly. So what the board is saying is the LTC is responsible for the behavior and activities of that LTP. If an LTP is grossly incompetent, makes all kinds of mistakes, does things outside of the law, and the board comes down on that preparer, the board is also going to come down on the LTC that was responsible for that preparer. And the only exception to that rule is if The licensed tax consultant can demonstrate to the satisfaction of the board that the circumstances that led to the violation occurred without permission or knowledge of the LTC, and that the violation occurred regardless of an adequate system of supervision that generally would have prevented the violation in the first place. Also, in the case of a corporation, firm, or partnership, the designated consultant and the corporation, firm, or partnership shall be disciplined. Consultant in residence. Well, I've been explaining to you what a designated consultant is and that every business has to have a designated consultant. But you might imagine that some businesses have more than one office. That's why we have the branch office registrations. And the tax board says that in addition to having the designated consultant that supervises all of the offices as an umbrella consultant, each of those offices must have their own consultant. And that consultant is referred to as the consultant in residence. So let's just go simply and say you've got a business that operates 3 locations. You have one designated consultant over the 3 locations, and then each location must have its own individual resident consultant. Now, designated consultant can serve as the designated consultant and the resident consultant for one location if that's where they work, and then the 2 additional locations must each have their own resident consultant. Now, resident consultant is one of the issues that many business owners butt up against. Finding enough consultants willing to be the resident consultant can be a challenge. And in the case of that business that was opening up an office, a branch office on the Oregon coast, it was their inability to find a resident consultant that caused them to apply for a waiver. The Oregon Tax Board said, sorry, the fact that you can't find a consultant means that probably you shouldn't open up an office. And they opened the office anyway. So each principal and branch office shall have a consultant in residence, and the consultant in residence must physically be present in that principal or branch office at least 50% of the time that the office is open to the public for tax preparation during each week from January 1 through the federal filing deadline without regard to extensions, which is usually April 15th, and then during each month for the remainder of the year in the year-round offices. So it's tax season, the resident consultant has to really be there 50% of the hours that it's open on a weekly basis. But once tax season is over, the resident consultant just has to show they're there 50% of the time the office is open in any particular month. In unusual circumstances such as death of a resident consultant, a business may apply for the resident consultant waiver from the board. The waiver will be granted only in limited situations after board review, which takes into account all relevant facts. And I can pretty much tell you that a shortage of consultants, you want to open up a new location and you just can't find one, isn't going to fly. Keeping of records. Each consultant shall keep records of all tax returns prepared for 4 years. But in cases where the LTC is employed by another licensee or firm, the employer is responsible for record retention. Now we're looking at Division 10, which is the Code of Professional Conduct, and we begin with confidentiality. A licensee shall not disclose any confidential information in the course of professional engagement except with the written consent of the client, or after being subpoenaed, or in response to an inquiry from the board, or as required by federal or state regulations for electronic filing. Integrity and objectivity. A licensee shall not knowingly misrepresent facts while preparing, assisting, or advising in the preparation of a tax return. However, doubt can be resolved in favor of a client if there is reasonable support for the position. A licensee who finds that a client has made an error or omitted information or related material required on an income tax return shall promptly advise the client of the omission. So basically, if you see that the client hasn't given you something, you need to let them know that something is missing. And in contrast, if you see you've done something wrong, you need to notify them of that as well. There's a two-way ethics issue. You can't ignore missing information or inaccurate information. You have to let the client know about it. A licensee shall not arrange for or permit a client's tax refund to be mailed to the licensee. A licensee must be current on all tax return filings and all tax payment plans pertaining to the licensee and the licensee's business before a license can be issued or renewed. That's that part where you have to be up to date on your own taxes. Fees in connection with preparation of tax returns must be stated separately from and in addition to any other professional services provided. So, for example, if you do bookkeeping, if you do payroll, if you have additional services that you're charging them for, you need to separately state those from what you charge for tax preparation. A licensee shall, upon written request by a client, make available or return within a reasonable time to that client personal papers or source material that belong to the client. Depreciation schedules must be provided if a client requests them in writing, and a licensee is not required to furnish records to a client more than one time, except in the case of a joint return where each spouse is entitled to a copy where requested. A licensee shall not engage in fraudulent, deceptive, or dishonest conduct relating to that licensee's professional practice. A licensee shall not violate a position of trust, including positions of trust that are outside of the business of tax preparation. Commissions earned for personal services of the licensee, such as real estate, insurance, investment, and securities sale, may be earned if the licensee holds any license, permit, or registration that is required by law to perform those services. A licensee shall disclose in writing that he or she will be compensated for any of these additional personal services, and the client needs to acknowledge receipt of that disclosure in writing. A licensee shall not engage in fraudulent, deceptive, or dishonest conduct relating to the licensee's professional practice. A licensee shall not violate any position of trust, including positions of trust, outside the licensee's professional practice. And a licensee must be current on all tax filings and all tax payment plans pertaining to the licensee and or the licensee's business before a license can be issued or renewed. Password number 1 is BORG, B-O-R-G. Okay, everyone, we'll pick up where we left off, and this time we're on to accountability. And here's what the Oregon Tax Board has to say about accountability. A tax consultant shall not permit the use of his or her license when the only interest is the receipt of a fee and the consultant does not actually provide supervision of the tax preparation business. So you might have a situation where a business says, we have to have a consultant, we'll pay you $10,000 for the tax fees, and all you have to do is let us use your license. And Oregon says, sorry, that's not legal. The consultant whose license is being used actually has to supervise that business. A tax preparer shall not prepare returns, gather information, or provide tax advice unless under the supervision of a tax consultant. A licensee shall not maintain a financial interest or employment with any person or business entity where such person or entity has a financial interest or management position over the operations of the business if that person or entity has had its license permanently revoked, or the board has refused to issue or renew a license to that person, or another state regulatory agency such as the IRS basically revoked their license or refused to renew it. Contingent fees. Contingent fees shall not be used where professional services are provided with an arrangement where the fee is based on the findings or results of the service. And the IRS has that same rule. You can't say, I'm only going to charge you if I get you an answer you like, or I'll charge you more if I get you a bigger refund. You're not allowed to have your fees based on things of that sort. Identification. A licensee shall include the name of the tax preparation business, the permanent address, and signature on the original and all copies of federal and state personal income tax returns or electronic filing documents prepared by the licensee, together with all the other data required by the Internal Revenue Service, Department of Revenue, and the State Board of Tax Practitioners. Office copies are exempt from this requirement. The state personal income tax return shall also include the signature and board-issued license number of the licensee who substantially prepared the return. So there has been some confusion about whose license number actually goes on the Oregon state return. And it's the license number of the tax preparer who prepared the return. It is not the license number of the designated consultant or the resident consultant, unless, of course, that's who physically did it. Address and telephone number. All licensees shall provide the tax board with their current mailing address, residence address, email address, and telephone number, and the current tax preparation business address and telephone number, and a year-round telephone number and address where the board can contact the licensee. A licensee shall notify the board within 15 days if any of the above information changes. Communications. A licensee, when requested, must respond to communication from the board within 15 days. And experience and competence. A licensee shall not prepare returns or give advice that is outside their field of experience and competence without the assistance of a person who is competent in the area of concern. Advertising and solicitation, there are some important rules here, and any tax office you end up working in or owning or running needs to be sure it's on top of these advertising requirements, because quite simply, just like having a license hanging in the wall, the tax board needs to be able to walk in and see it there. If they look at a piece of advertising for your business and it's out of compliance, I mean, they can just instantly find that. They don't have to do an investigation or anything because it's like right there in front of them. They have their evidence. So you want to be on top of this one. Basically, advertising and solicitation, as it is used in this rule, advertising and advertise means any form of printed, broadcast, or electronic material that makes known the professional income tax services. This includes, but is not limited to, business cards and stationery and all web and e-commerce advertising of an individual or tax preparation business. No licensee or tax preparation business shall advertise or solicit clients in a false, fraudulent, deceptive, or misleading manner. And all advertising must include the name of a firm that has complied with the Oregon administrative rules or the Oregon state law. And it must state the name of the firm's designated licensed tax consultant. Also, the only person who can use the abbreviation LTC or the name licensed tax consultant is a person who actually is licensed as a consultant. And the same holds true for tax preparers. You may not use the designation LTP or the title licensed tax preparer unless you in fact hold the valid license. All advertising must be reviewed and approved in advance by the designated licensed tax consultant. The designated licensed tax consultant and the designated tax preparation business or the designating business shall each be responsible for the business's compliance with the provision of these rules. So again, if you are a licensed tax consultant and you agree to be the designated consultant for a business that is not your own, that business is required to get you to approve any advertising that they run. And then you are responsible for ensuring that that advertising is in compliance with the law. Also, no licensee shall advertise or give a discount unless the discount is based upon a basic fee schedule posted in public view in the licensee's place of business, and the fees on that posted basic fee schedule are the usual and customary charges of the business, and the basic fee schedule includes the minimum fees charged for at least the following forms and schedules: 1040, 1040A, EZ, Schedule A, Schedule B, Schedule EIC, Form 2441, but it is now Schedule 8812, and then the Oregon Form 40. All business advertising must include the board-issued business registration number of the firm, written as OBTP, or the license number of the firm's designated consultant, which should be written as LTC. So if you have a business advertising, like a yellow page ad or an ad on television or an ad on the radio or ad on the internet, the license number of the designated consultant must be shown, or else the OBTP number of the business itself must be shown. All individual advertising must include the licensee's board-issued LTC or LTP license number, and that would include things like business cards. If you are handing out a business card to a client, your LTP or LTC number needs to appear on that card. Education under Division 15, this is basic education. A basic income tax course may be offered by an accredited college or university, an educational service district, or a private firm that has met or is exempt from the registration requirements of the Oregon Department of Education, or a private firm who is offering classes only to its own employees and is exempt from the Oregon Department of Education requirements. Sponsors shall apply for course certification on a form that is provided by the board, and a basic tax course shall include at least 80 hours of basic tax preparation instruction. If the course is offered through correspondence or online, it must be the equivalent of 80 hours of instruction. Instruction in each of the subject areas is specified in the Preparer Examination Index, which is maintained by the board. Also, each course has to have sufficient working problems to instruct on the use of appropriate forms and schedules, and it must administer a midterm and a final exam. The board shall require a sponsor applicant to submit evidence that the course materials and lesson plans comply with its rules, and basic course sponsors shall employ only instructors to teach basic tax courses who are actively licensed or who are exempt from being licensed, and who prepared taxes for at least 2 tax seasons immediately prior to teaching the course. And this is something where there was quite a big hoopla going over at the Oregon Tax Board not that long ago, because one of the larger franchised offices in Portland was using an instructor who was not licensed and had not been licensed for some time, and so they got a bunch of fines for that. So again, whether you're taking a basic tax course or teaching a basic tax course, you need to be in compliance and make sure you have an instructor who is approved and meets those requirements. The board may grant a specific waiver for an instructor qualifications when unusual or extenuating circumstances exist. An example might be you had an instructor, but they died in the middle of it, and so now you're kind of stuck and you have to substitute someone else. Sponsors shall submit to the board the name and qualifications of instructors teaching the basic tax course. Repeated low passage rates of an instructor's students on the tax preparer's examination could be evidence that that instructor is not qualified to teach a basic tax course. So the tax board does actually publish pass rates for all of the instructors that teach each year, and they look to see those pass rates. And if you are an instructor who has a good pass rate, you get this letter that comes to the board that says, good for you, you're a great instructor. And if you have a low pass rate, then you get another letter that says, gee, you need to brush up a little, or maybe we're going to not approve you anymore. The instructor's approval for each basic tax preparation course can be revoked by the board, and evidence of successful course completion shall be furnished to students by course instructors on a board-approved session attendance certification form. Forms may be reproduced by course instructors. If a student misses a portion of the class sessions, the instructor may provide make-up work. Well, one of the things I've always done with our basic tax course when I teach it is, firstly, you can't teach everything you need to teach a student in 80 hours. It's way longer than 80 hours anyway. And so if a student were to miss 1 or 2 sessions when we did still hold it in the classroom, they would still have 80 hours. But we basically said, if you miss more than 2 sessions, we're going to flunk you, because you just have missed too much. Now that we offer our course only online, it's easy to make students take every session. They can't miss any. They aren't even allowed to move on in the course until they've finished each session. And that's really, really important. If you miss any sessions, you've just missed a piece of tax law. Oh, I missed a session on itemized deductions. I don't know how you're going to make it as a tax preparer if you don't know itemized deductions. And essentially every session we teach is just as important as that one. Continuing education. Except for renewal of an initial license, each tax consultant or tax preparer renewing a license has to provide evidence that they've completed 30 hours of continuing education since their last renewal date. But education hours in excess of 30 cannot be carried forward and used in a later year. The only exception to that is education received in the renewal month. And for preparers, the renewal month is September. For consultants, the renewal month is May. And if you get any CPE during the renewal month, you can carry that forward to the next year or use it for the current renewal, whichever one you prefer. Now, if you attend a course more than once during a year, you can only get credit for that course once. Continuing education credit for instructors. An instructor can receive credit for the time they put into instructing. The credit shall be 2 hours for each hour of teaching, which does include preparation time. No more than 1/2 of the annual CPE requirement can come from teaching, however. So if the requirement is 30 hours a year and you are an instructor, the most credit you can get for being an instructor is 15 hours. You still have to go somewhere else and get 15 hours from another source. Continuing education credit for courses at accredited universities and colleges will be 15 hours for each college semester hour credit, and then 10 hours for each quarter hour credit. Correspondence and online courses may be accepted if the program and sponsor comply with the board rules regarding continuing education, and the sponsor requires evidence of satisfactory completion of workbooks or examinations before certificates are issued. The hours credited do not exceed the credit that would be allowed in a resident course covering the same material, and a course outline with the accompanying workbooks or examinations is submitted to the board prior to offering the material for approval of the course content and the hours of credit claimed. However, the board no longer requires direct approval of every course offered by a provider if that provider is already approved by another body that goes through approval processes for the sponsor directly. And currently the board accepts sponsors who have already obtained approval from any of the following: the California Tax Education Council, the IRS, or the National Association of the State Boards of Accountancy, also known as NASBA. So if you want to take CPE, you need to get your CPE from a school that has been directly approved by the board. And in order to see who the board has approved, you have to go to their website and look up a list to see who they have approved. And actually, the board not only lists who they have approved, but they list the individual courses that they have approved and the number of hours awarded to each course. After working with the board for a number of years on CPE and submitting hours to them, on top of already having been approved by these other agencies, including NASBA and California Tax Education Council, I just went to the board one day and I said, is it really necessary to have you guys go through all of this review process and award different hours to my courses than other agencies have already said we can give them? You're kind of just duplicating work. You're making it confusing. Why don't you just say, hey, if you've got CTEC or if you've got NASBA, you're done. And the board actually thought that was a good idea. And so we now have this rule in here that says if the school or the institution that is offering CPE can already show that they have been approved by one of these agencies, then all of the courses from that school automatically meet the board standard and will be approved by the board. And so in the case of Pacific Northwest Tax School, we have approval from CTAC, we also have approval from IRS, and we also have approval from NASDA, so we got it all over the place. And it is not necessary to go and look to see if we're approved by the board, because it's no longer the case that we would be shown individually as approved by the board when we've already been approved by these groups. In-company instruction can be accepted if the course or seminar is presented to 10 or more people at a time and all other requirements for CPE sponsors are met. Portions of such educational sessions that are devoted to administrative and firm matters are not going to be accepted for CPE. Continuing education audit requirements and documentation standards. Essentially, the board says that you have to maintain proof of completion of a course. And when you submit your application for renewing a license, they will ask you to testify that you've completed the correct amount of hours or the number of hours that you have taken. And then the board could actually audit you. And if they audit you, you've got 30 days to submit proof that you've actually completed the courses that you said that you took. And proof includes a certificate of completion or attendance at a program, seminar, or course that is provided by a sponsor that includes the name of the student, the name, address, and phone number of the sponsoring institution, the location of the program, the title of the program and a description of its content, the name of the instructor or the presenter, the dates of attendance, and the number of hours of instruction that were completed. Also, a copy of an official transcript, diploma, certificate, statement, or affidavit from a college or university can work. If documentation of continuing education is invalid or incomplete, the licensee must correct the deficiency within 30 days from the date of notice. Failure to correct the deficiency within the prescribed time shall constitute grounds for disciplinary action. And misrepresentation of continuing education or failing to meet the continuing education requirements or documentation may also result in disciplinary action, which may include but is not limited to the assessment of a civil penalty and suspension or revocation of the license. So don't lie on your application, say you got hours that you didn't get, and don't try and submit fake hours and hope they won't figure it out, because if they do figure it out, the penalties can be severe. Continuing education program requirements. So we've talked about how you have to take the education from an approved sponsor, at least if it's a correspondence course. It doesn't have to be an approved sponsor if it's just like in a classroom or in a webinar, but if it's a correspondence course or an online course, it has to be pre-approved. In addition to that, the program itself has to be of the appropriate subject matter. It has to be tax related. It has to lend to the knowledge base you need to be maintaining as a tax practitioner. Acceptable continuing education is that which contributes directly to the expertise of an individual in the preparation of income tax returns and is presented by a sponsor who meets the requirements of all rules. It is the obligation of you, the licensee, to select a course of study which will contribute to your competence in the preparation of tax returns. Examples of acceptable programs include programs in taxation, practitioner ethics, accounting and payroll theory, estate tax or investment planning, computer technology that is used for preparing tax returns, tax representation, exam collection or appeals, or other programs if the licensee can demonstrate a direct relationship to the preparation of a client's tax return. But unacceptable programs include things like memory improvement, buying or selling a tax practice, setting fee schedules, character development, behavior modification, business management, labor law, economic forecasts, or learning to operate office equipment. None of those would be deemed acceptable towards that 30-hour requirement. There is a 50-minute hour rule, and that's pretty consistent. NASDA has it, CTAC has it, the IRS has it, and so does the tax board. It essentially says that for each hour of education you receive, you have to actually be learning and listening to an instructor or involved in classwork for 50 minutes out of the hour. So you'll see that's why I go close to an hour, I give a 10-minute break, and then we go another hour before another 10-minute break. And in fact, I usually have one less 10-minute break than is allowed, because in a 2-hour class, you'll get one 10-minute break, and in a 3-hour class, you'd get 2 10-minute breaks. So we're always a little bit under on the time, but if you're going to a school that's giving you 15-minute breaks every hour, then that would be out of compliance, and you wouldn't be allowed to receive full credit for that. Qualified instructor. Programs must be conducted by a qualified instructor whose background, training, education, or experience make it appropriate for that person to lead a discussion on the subject matter of that program. Again, no credit for repeat classes. Education and basic sponsor requirements. Education sponsors are required to keep records for at least 4 years following the delivery of a program. And that includes the outline, the record of attendance, and information relating to the instructor, the name of that instructor and the qualifications of that instructor. Also, the school must provide the student with a certificate or other verification of completion at the conclusion of the program, and that certification shall include the name of the student, the name and address and telephone number of the sponsoring institution, the location of the program, the title of the program, and the description of its content, the name of the instructor or presenter, the dates of attendance, and the number of instruction hours. Also, sponsors must conduct their programs in an honest and ethical manner. Procedures for examinations, because that's what you're preparing for now, right? To take a test. Both the tax preparer and the consultant examinations have a passing score of 75% or higher. Pass-fail results will be provided to each applicant in writing and by no other means. No review of examination questions by the applicant will be granted. An applicant who fails to pass the examination shall be eligible for a succeeding examination upon making application and paying another examination fee. A tax preparer applicant must retake the basic tax course if after 3 years from basic course completion date they have not yet passed the preparer exam. And an applicant who passes an examination must apply for licensing within 60 days from the examination date. If application for a license is not made within 60 days, the applicant must retake the exam unless there are verifiable circumstances beyond the reasonable control of the applicant, and this is subject to the discretion of the board. Examination conduct disqualification. Examinee shall be disqualified for inappropriate conduct, details of which can be found in the reference I'm showing you here. License renewals and reactivation. Licensed tax consultants and preparers shall display their licenses in public view in their place of business. Each registered tax business and branch office must also post its registration in public view. LTC licenses expire May 31st and LTP licenses expire September 15. Any license that has not renewed within 15 days of the renewal date shall lapse. A lapsed license may be renewed upon payment of all past unpaid fees and after proof of compliance with continuing education requirements is provided to the board. The board has the authority to waive the CPE education requirements under certain circumstances. Prior to annual license expiration, a licensee may file for inactive status, which may be reinstated after submission to the board of evidence of completion of all required CPE and applicable fees and payment of the applicable fees. Inactive licenses will lapse after 3 years. So essentially, let's just say for whatever reason you don't want to renew your license this year. Something's happened, you're just not going to work in the business this year, so you don't want to have to do it. You can go into what we call an inactive status, but you can only go to inactive status before your license expires. If your license expires, you're not eligible for inactive status. And you can stay in inactive status for up to 3 years. At the point where you decide you want to go from inactive to active, you're going to have to show that you've obtained all of the necessary CPE for the period of time you were inactive, as well as for the license renewal that you went inactive during that period. So if you're inactive for 2 years, then you're going to have to show 2 to 3 years of CPE when it's time to renew. It just depends on the window of time we're talking about. Finally, Division 30 is just miscellaneous topics. Division 30 covers civil penalties, inspections, evaluations, and investigation, board meeting procedural rules, board meeting minutes, and obtaining and purchasing board-provided materials and services, including how to advertise and what it costs to pay for an advertisement in the board newsletter. Among those provisions listed in Division 30 are inspections, and if the tax board decides to inspect you or your business, you're not allowed to impede that inspection. You have to basically open your door and let them in. If you threaten the investigator, if you impede that investigator, that can be cause for more fines. Business owners must contact the board within 5 business days to make any necessary arrangements for an inspection. So an inspector might just show up on your doorstep unannounced and you're supposed to let them in. But if they let you know ahead of time that they're coming, you need to contact them within 5 days of the issuance of that notice to make arrangements for them to visit your office. Typically, they say that that happens if they came out to investigate your business and it was closed. Tax board communications, how can you express your opinion to the tax board? Well, the board holds public meetings about 5 times a year. These meetings are not generally scheduled during tax preparation season. Most meetings are held in the large conference room at the Morrow Crane building located in Salem. Much of the sessions that they have are closed sessions. In other words, the public is not allowed in, but they do typically have one day in the longer sessions where the public may come and speak. And there's usually one major session held each year, which is considered to be a public session, where they actually have a luncheon. But they make a point of making that public presentation or public luncheon different points throughout the state every year. So they try to make it possible for people who don't live near Salem to make it out to them. And so you'll see that they'll hold one out in Ontario, Oregon, and one out in Klamath Falls. Over time, they move around the state. But within the state, there's only one real big public meeting once per year. So you can go to that meeting and you can make your case, stand up and speak to the group if you wish, speak to the members of the board, present your case, or you can just send them an email and say, hey, I have this thought. And for example, I emailed and said, you know, these RAL rules that you've got there, they're kind of obsolete. Maybe you should take a look at changing those. So they actually emailed me back and said, thank you, April. You are spot on with something there. We do need to sit down and figure out how to rewrite these rules. And so that's something that's now on their agenda. If you have ideas like that, that's how you get them to them. And finally, if you see that someone in your profession is violating ethics rules, who do you tell? The person you tell is Heather Shepard. She is the Compliance Specialist Investigator, and this is contact information for the board. And you can, of course, pick it up and call. And that concludes the ethics portion of today's class. We're now going to move on in the last half hour of today's class, just basically talking about the examinations themselves. And I'm going to start with the Preparer examination, and then I'll move on to the Consultant examination. Before I do that, though, I'm going to open up Sharing Pod here to show you the General Information Booklet. Because every year the Oregon Tax Board releases this General Information Booklet, and you find it on their website. I already showed you earlier today where it is. So you go to the website and you look for this booklet. And if you go through the booklet, it contains an index, how to become licensed, the fees, refunds, exam content and procedure, all of the good stuff that you may have questions about if you've not already read the booklet yourself. It also shows you who approved course sponsors are. It shows you some resources on what you need to know or what you need to study for if you're preparing for the Preparer test, what you need to know and what you need to study for the Consultant test, and other exam site information, including Proctor site information. So if you happen to live out in Ontario, Oregon, I seriously doubt you're going to want to make the 2-day drive through the mountains and across the state to make it to Salem to take the test in December. It'd probably cost you far less money, saving all that gas and hotel charge, to just find a local Proctor somewhere near Ontario and take the test there. And that's with the exam Proctor site information, which is on page 38. So let's just go to so you can see Proctor site information. So you can see there's lots of choices here. Lynn Benton Community College, Central Oregon Community College, University of Oregon, Klamath Community College. They go on and on and on. So you just need to find the community college somewhere near you and inform the tax board that you want to use that particular community college when you submit your application to take the test. And you will see that most of these Proctor sites have Proctor fees, and the Proctor fee is listed. You can see it ranges anywhere from a low of $25 to a high of $60, depending on which Proctor site you go to. So it adds significantly to the cost, but with gas prices where they are today, that's a relatively probably minor price to pay overall in taking the test. And they don't have the information here. It's somewhere else on their site. I'm going to actually go to their site and show you something else. On their site, under Exam Information, this tab right here, you can go down and look at pass rates. And they go back in time showing the pass rates for schools. And those can be interesting for two reasons. One is, have you decided to pick a school, or did you choose a school that has a good pass rate? No guarantee that you'll pass, of course, but high pass rates consistently from a school are an indicator of the overall quality of the program. But it can be interesting just to look at how many people took the test in the last exam cycle. And you can see this is for exams taken between March 1st, 2012 and 2/28 of 2013. So it's a 1-year period. How many took the test? Well, 520 people took the Preparer test, of which 310 passed. So the pass rate is 60%. I'm going to point out something for you about this pass rate, because this is an exam strategy for you. For most of its history, the Oregon Tax Board had completely closed book examinations for the Preparer and Consultant exam. And the pass rates seem to consistently hover in the 55 to 60% range. Over time, tax law has gotten more complicated, and so overall pass rates, I think, were kind of going down. And so the tax board was looking at, what can we do to increase pass rates? And the theory came up, well, maybe if we make the exam open book, the pass rates will go up. And when they proposed that, I was dead set against it. I thought, that's just ridiculous. I took a closed book test. Everyone I ever know or hire has taken a closed book test. You need to be able to pass a closed book test as evidence that you know what you know. But the tax board has 7 members, and the majority of members, not all, but the majority of members did vote to make it open book. And so it became open book beginning in 2009, where they were testing 2008 law. And in that year, the pass rate jumped. It was a big jump, way up. Pass rates improved tremendously. But this was my theory. They made a decision to make that test open book well into the education season. If you look at the education season for tax schools, people usually enroll at the beginning of September, and then they take that test in early December. So it was sometime around October-ish, or even at the beginning of November, that the board announced that the test was going to be open book. So everyone who was studying for the test at that point in time had been studying for a closed book test. And when they went and took that first test that was offered open book, the pass rates really went up. But what's happened since then, since 2009, so 2010, 2011, 2012, and we're looking at these exam results that came through the 2012 through 13 cycle, we can see the pass rates are right back down to where they used to be. And why is that? It just takes a certain amount of knowledge and study to be able to pass a test. You can't pass a test without knowing your stuff, at least the board tests. And so those individuals who had been studying really hard and who had that extra crutch were able to pass the test. And over time, people have gotten a little bit lazier. They're saying, it's open book, I don't need to know it as well because it's open book. Well, the thing is, it's a 5-hour test with 200 questions. You're going to go in there, and if you don't really answer those questions, you're going to be spending all your time looking up the answers. And you're not maybe even going to be sure where those answers are. And so the clock will either run out, or you're still going to be guessing at a lot of those questions. And therefore, we have this pass rate that each year has been dropping and dropping and dropping. Now, let's look at the next category here, the consultant, including retakes. We have 95 people who took the test, and this is actually an increase. 33 passed out of 62 for a 35% pass rate. That's actually a pretty big jump because the pass rate's always been closer to 25%. So I'm thinking, what's happened? Something has sunk in where people are having a higher pass rate. It would be interesting to find out why that pass rate has gone up a little. I'd like to take the credit and say, oh, those are people who took my course. No way to know that for sure. The consultant state-only portion, 82 people took it, 49 passed. So if you're taking the state-only portion of the exam, the likelihood of passing is 60%. And then the total consultant preparer exam administered, including retakes, 56% overall pass rate. So those are pretty low pass rates overall. Now, how many people took the preparer and consultant exams? 658. The total who passed was 356. The total who failed was 302. So the total pass rates for all of those exams under this statistical count is 54%. So think about where you're at. Am I going to be in the 35% who passed the consultant exam? Am I going to be in those 60% who passed the preparer exam? How am I going to make it so that that is a truism for me, that I am one of those people that passed? And the answer is, well, you need to know your stuff, but you also need to know a little bit about how to prepare for that test and the types of things that you need to know when it's time to take that test. So let's again move back to the manual and take a look at this preparer examination outline. And you've heard me already say that both the consultant exam and the preparer exam have 200 questions. So if you look in here and it says federal, how to file is 13.5% of the questions on the test, that essentially means that there's going to be about 27 questions on the test that have to do with filing requirements. Filing status, dependents, personal exemptions, you got to know that information. So don't discount it. And these can be some of the hardest questions on the test. Filing status questions get missed all the time. And there's no reason to miss filing status. On the other hand, teaching filing status and having preparers work for me, I know filing status is hugely confusing, and even people who've been working in the business for 5 years or more still get confused on filing status. So don't discount it. Bone up and make sure you know filing status and dependents and the rules for claiming exemptions. Then we move on to income. And if you look at all of the different kinds of income that they're going to test on in the prepare test, Only 11.5% of the test is on income, compared to 13.5% on filing requirements. That's significantly interesting, because we might look at income as more important. How am I going to report income on a tax return? What are the rules about the taxability of income? That would seem to be really important stuff that you need to know, and yet less weight is put on it. 11.5%, or roughly 23 questions of the Preparer exam, are going to be on income. What is earned income? How are tips taxed? How is interest and dividend taxed? Business and farm income, retirement pensions, rental, depreciation, Social Security, investment, all other income lumped into just 23 questions. But then we move on to something about assets. There's 8.5% of the exam is devoted to assets, and that's looking at the sale of assets, the basis of assets, the sale of business property, sale of home. So that's a pretty heavy weight on assets, disproportionate to income, I think. And then adjustments. There's going to be 10 questions on adjustments. And so if you narrow it down into the different types of adjustments, there's probably going to be 1 or 2 questions on IRAs. There's probably going to be a question, at least one question on alimony. There's probably going to be a question on self-employment and moving deductions, education expenses. So if you just look at the number of categories, you can pretty much figure out there's going to be 1 and at most 2 questions on each of these topics. Itemized deductions, 15% of the test is on itemized deductions. That's 30% of the exam is devoted to itemized deductions. And what are the rules and the phase outs? Who can do this? What's deductible? What's not? You need to understand that information. Credits, 5% of the exam is devoted to credits, and you can see that we've got more than 5 credits listed. So on average, each credit is going to have 1 or at most 2 questions devoted to that specific credit. Other taxes, only 2.5% of the exam, or a total of 5 questions, is on other forms of taxes that might be imposed on a tax filer. And there are more types of taxes than there's going to be questions on those taxes. It tells me that the depth of knowledge that they'll probably ask is not too intense, but you should probably have an overall understanding of each of the types of other taxes and when a person needs to pay them. Also, 2.5% of the exam is on estimated tax and other types of ways of making payment. Continuing on with the examination outline, you move on to Oregon portion of the test and how much of the test is going to be devoted to Oregon law. And you can see how to file is going to be roughly 8 questions. Additions are 3% of the test, 6 questions on additions. Subtractions are going to be 12 questions. Deductions, another 3 questions. Credits, another 6 questions. Payments, a couple of questions. Licensing law, that was the topic of today's class. 12 questions on the hour and a half I spent on licensing law. Those have got to be the 12 easiest questions you'll get on that whole test. So make sure you read through all of those licensing law provisions. They're easy give-me's if you've read them. And then finally, you'll see here mini problems. 12% of the exam is on mini problems, and those mini problems will cover both federal and Oregon law. Now, there are no mini problems per se on the consultant exam. They are more devoted at the Oregon tax preparer level. But mini problems can be complicated, and lots of preparers flunk the exam because of those mini problems. If you are studying for the preparer exam, they've kind of narrowed it down a little. They're saying it's still sort of semi-open book, but these are the only publications you will be allowed to bring into the examination site. Prior to this, you were allowed many other publications, but they've narrowed it down, essentially saying Pub 17 and the Federal Form 1040 instructions. On the Oregon side of things, you're allowed 17.5, the Oregon instruction booklets for Form 40 and Form 40 and 40P, as well as the Oregon administrative rules and the Oregon revised statutes. You are allowed to bring those into the test site still currently. Moving on to the consultant examination, you will see that the percentages change significantly. Remember how for the preparer test, 13.5% of the test was devoted to how to file. By the time you're up to the consultant exam, they're only looking at 5%. But they're still looking at 5%, which means there will be 10 questions, and they'll probably be fairly difficult questions on how to file. Their filing status questions are probably going to be tough ones, and you need to really know filing status to get those right. And if you look at the consultant exam having a pass rate this past year of only 35%, and 5% of that test is on filing requirements, but you haven't boned up on that, that could be the reason you flunked the test. Earned income, 2.5% of the test. Interest, 2%. Dividends, 2%. So they're kind of breaking it down more narrowly here, saying, you know, if you're taking the consultant test, not only do you need to have a general understanding of interest, we want you to be able to identify the difference between taxable interest, exempt interest, and original issue discount. Dividends, what's the difference between ordinary, non-taxable, and capital gain dividends? You should be able to explain that. Business income and deductions. Now we've got a distinct thing here. 5.5% of the test, or 11 questions roughly, is going to be devoted to business. And earlier, under the Preparer exam, it would have just been 1 or 2 questions. So this is a significantly heavier weight being put on business. Also, they're going to ask about 6 questions on passive activities and rental properties, and roughly 3 questions on farming. Pensions and annuities, you can expect around 6 questions on that topic. Social Security, 1 or 2 questions there. Depreciation, a total of 8 questions are going to be coming your way on depreciation. That's a significant percentage, and you'd better understand depreciation, know the rules for it. Sale of business property, 15%. Back when I took the consultant exam, and this was way back in 1995, I passed the consultant exam. And at that time, they had the consultant exam actually divided into 2 parts. You could study for each part independently. You could take them both at once. You could take one, take the other. It was kind of nice that way. I liked it that way. And back when I was studying for the consultant test, I observed that a full 40% of 1/2 of the exam was devoted to the sale of property. You've got to get that concept of how to determine the basis of property, what the rules are for determining capital gains, the rules around sale of your residence, installments and repossessions. You've got to know that stuff, and you've got to know it really, really well. So if you haven't already taken some of Pacific Northwest Tax School's courses on sale of assets, you should bone up on them. I get into it in such a way, to such a depth, that you would be able to walk into the Oregon Board exam feeling good on those topics. Miscellaneous income, 3%. Itemized deductions, 9.5%. So on both the Preparer exam and the consultant exam, itemized deductions weigh fairly heavily. Credits, 3.5%. Other taxes, 2.5%. Net operating losses, they'll throw in 1 or 2 questions for you on NOLs, and that's a fairly advanced topic, NOLs. Amended returns, 1.5%, and other areas that are not identified, 2.5%, as well as adjustments at 4%. If you are studying for the Oregon portion of the consultant exam only, or if you are studying for the entire exam, of which part is the Oregon exam, this is the breakdown of the Oregon exam. How to file an Oregon return. So filing requirements surrounding the Oregon tax return. What are your filing status choices for Oregon? Filing requirements for Oregon. What are the rules relating to non-resident filing requirements and exemptions? Additions are 3% of the test. That means you can really expect about 6 questions on Oregon additions. And the main one that they're going to be getting into are these municipal bonds, and then also add backs for items that were deducted on the federal return, and then you claimed an Oregon credit for that same amount, such as you're paying for long-term care insurance and you are able to claim a credit on the Oregon return, and then you claimed an itemized deduction on the federal return, and that will create an addition. So Oregon expects you to be familiar with additions. Subtractions, they've got more on subtractions, but I don't think significantly more, given that there are so many more subtractions. But they're basically saying they're looking at subtractions for tax. How do you figure the Oregon subtraction for taxes paid to the federal or foreign taxes? How do you claim a subtraction for interest? That means what kind of interest is taxable on the federal return but not taxable on Oregon? Military pensions, who is eligible for a military pension subtraction and how do you figure it? Other pensions, other subtractions, deductions, including the Oregon Standard Deduction, Oregon Itemized Deductions, and the Oregon Special Medical Deduction. Credits, child care, political, exemption credits, retirement, the Working Family Credit, and other. Payments of estimated tax, part year and non-resident rules, and finally license law. Again, that was today's topic, so you can be expecting roughly 11 questions on the Oregon portion of the exam that have to do with Oregon licensing law. Now, if you are studying for the consultant test, the Oregon Tax Board has published a list of all of the publications from which it draws its questions. So in other words, if you're studying for the consultant exam and you are saying, exactly what is it I'm supposed to know? What you're supposed to know is these publications. You should have read them all, cover to cover, and know what's in them. So part of preparing for the Oregon consultant exam is to know the content of all of these publications, and these are the Oregon publications you should have read and know the content of. Now, there is a reference sheet that is provided at the examination site with the examination materials. I call it the cheat sheet. When I took the consultant exam, there was no cheat sheet. When I took the Preparer exam, there was no cheat sheet, plus it was closed book. But they do give you the cheat sheet at the exam site now. So when you go in there, these particular numbers that you may have been worried, do I have to have these numbers memorized? The answer is no, because they're going to give you this cheat sheet that you can quickly reference. And among the important things that are on it are the phase-outs for various education deductions and IRA deductions and credits that a filer might qualify for. So if they give you a question that says, Joe has adjusted gross income of $90,000 and he paid $4,000 in tuition and fees, his deduction will be blank. Tuition and fees deduction, phase out for single is 0 to 65,000. The answer would be 0 because they're outside of the phase out. So back in the days I took the test, we were expected to know those numbers in our head, but it was decided by the board that numbers that change over time shouldn't need to be memorized, and we'll just give you this cheat sheet. So that's something that you will have as a crutch. For Oregon, the cheat sheet will include the schedules showing the Oregon deductions for various filing statuses. And they also give you the table for figuring the Oregon Child and Dependent Care Credit and Oregon Exemption Credit tables. So all of this information will be provided to you on the cheat sheet. There's more in here on the exemption credits and so forth. So I'm going to flash through now to something else that you should be paying some attention to. Each year when Oregon publishes that examination booklet, the one with the bucking bronco on it at the start, that booklet contains a list of the most frequently missed preparer questions and the most frequently missed consultant questions from the last examination cycle. In front of you now, we have a list of most missed questions from the most recent cycle, which is the 2012 through 13 exam cycle, which covered 2011 law. And any of the questions you look at in here will reference 2011 publications. Well, you're studying for an exam on 2012 law, aren't you? So when you look at what the question was for 2011 law, you may have to make some adjustments for changes in the standard deduction, changes in phase-outs, just changes in the law in general. So looking at the old questions can be helpful for two reasons. One is it shows you how the board words questions, so that when you go into the board examination, you're not seeing a question the way they word it for the first time. You're going to be familiar with how it is that they word their questions. But the second reason is, give you a little hint here, they reuse questions. They have a bank of questions. I don't know how many questions is in their bank. Quite a few, several hundred, probably even a couple thousand of questions are in their bank. But they reuse those same questions year after year after year. And so a question that you see on this list that is the most frequently missed question, there's a good likelihood you're going to go in to sit down and take the test, and it's going to be on the test. So it's like a freebie. It's give me. At least know how to answer this question, because if that question comes up, you can answer it. And even if the question doesn't come up exactly worded the way it is, which it could, there's probably another question very similar that would replace it. So we can see here that we have the first question on this list says, Janet, a single parent, attends college full-time. She is studying for her master's degree. Janet's tuition is $6,000. The lifetime learning credit on Janet's return could total what? And your job is to pick the most likely answer. What is the correct answer, do you think, to question number 1? $1,200, because the lifetime learning credit is based on 20% of the allowable expense up to $10,000. Her tuition is $6,000. You multiply that by 20%, you've got the correct answer. So that was an easy one. The next one, you can see, is a mini problem. And to get this problem correct, the examinee has to go through and prepare a Schedule E using the information provided in the problem and then figure what is the correct answer. And so in preparing to take the test, whether you're preparing for the consultant test or the preparer test, I would go through and do this problem. Because although the consultant test won't actually have you fill out a form, it may ask you the exact same kind of question without giving you the form. So you should still go through and be able to select the correct answer. And the best way to do this is to do it cold without looking at the answer ahead of time and just see how you do. Because when you actually do finish taking the most frequently missed questions, they do actually give you an answer key here. They're providing you with 13 questions out of 200 questions that appeared on the Oregon Preparer exam based on 2011 law and what the correct answers to those questions were. We then move on to the sample consultant test with frequently missed questions, and these are going to be a little tougher. And it says taxpayer's W-2 shows allocated tips of $2,000 and Social Security tips of $500. Taxpayer did not keep a tip record. Taxpayer is required to pay additional tax on tips of $2,000. So this is what I would expect is the correct answer. So they're going to have to figure out how much additional tip tax they owe on $2,000 of tips received. So your job is to go through and look at these questions and figure what you think the correct answer is, and then see how you did. And we're going through here. Oh my gosh, they've given you 30 frequently missed questions out of 200 questions on the test. That's a huge give me, give me, give me. And here are all of the answers. And they're telling you where the referenced answer can be found. Now, in the Pacific Northwest Tax School tests and quizzes that we give you, we actually tell you the publication and the page number and maybe even where on the page to find the correct answer. Oregon Tax Board's not nearly as nice. They merely tell you what the correct answer is and that the answer can be found somewhere in Pub 17. Your job is to figure out the rest. Now, I've been teaching the basic tax course since 2001, and I've been reading the Oregon Tax Board's examination book since 2001. And every year I save the pages they have on most frequently missed questions. And so here now we're up to sample prepare test with most frequently missed questions covering 2010 law. And if we keep going, we're going to get most frequently missed consultant questions on 2010 law and the answer keys. And then we have 2009 law. And you will see that this manual is 138 pages long because it takes 138 pages to show all of the most frequently missed questions from all of those earlier exams. And if I go to the very last page, we actually have our own little quiz at the back here for people who are doing the homework assignment. But you can see the very first year that I have sample questions for is 2001 tax law. Now, back in the day when they gave out the most frequently missed questions, they only gave the questions. They did not provide you with possible answers. And we ourselves have not gone through to speculate on what those correct answers are. But it is still potentially possible that a question like this one, even though it is a 10-year-old test, could still appear on the exam. And so what I would do if I were you, I would look at the questions that appear in here and translate those as best I can and say, hey, does this question look like it could be relevant to 2012 law, which I'm currently studying? And if so, how would the rules have changed so that this question would be reworded for 2012 law? And if so, what would the correct answer be based on what I'm being provided here? But again, we haven't gone through any effort to provide you with correct answers because A, the question may no longer even be relevant because law has changed, or it would have changed in a significant enough way that telling you what the correct answer today isn't necessarily going to be helpful because it's going to have to be updated and corrected for changes in the law. But still, they're there for you to peruse and learn from. And really, federal tax law has existed in its current state since about 2008. So rules that have been in place in 2008 through 2012 and even through 13 are going to be fairly constant. We can expect that 2014 and future years, or even parts of 2013 and future years, are going to be significantly changed. But we've been pretty stable in terms of how tax law looks for the past several years. So many of these questions will be completely relevant. So that's it. That concludes my last session in our Oregon series on Oregon ethics and strategies for passing the Oregon Preparer and Consultant exams. Your question is, how many hours of education will equal 1 hour of work experience? Well, let's read this here. You may substitute education credit in lieu of up to 365 hours of the 1,100 at a rate of 1 classroom hour for each 5 hours of experience. So that sounds like you could get 10 classroom hours would equal 50 hours of experience. That seems to be what they're saying. That's the way I interpret it. The reverse is the case with VITA hours. If you're working for volunteer, you seem to get fewer hours for volunteer work than you do for paid work. Thank you for participating in Pacific Northwest Tax School's education programs, and we look forward to seeing you again soon. Bye-bye. Password number 2 is FOAL. F-O-A-L. FOAL. This concludes the lecture video for this course. Please follow these procedures to complete course assignments and receive your certificate of completion. Go to the assignments page and complete the password test. Refer to the classwork and homework assignments in the student manual. If this course's assignments require you to complete tax forms, go to the Forms page of Open Campus to print forms you will need to complete as a part of these assignments. As an alternative, you may use tax software for completing your assignments. However, we recommend you complete forms by hand, as hand completion provides a more thorough learning experience. When you are finished preparing assignments, go to the Assignments page. Click on the assignment you have completed and enter your answers. When finished, click Save and Submit to record your responses and receive your score. If you receive a passing score, you can go on to the next assignment. When you have received a passing score of 100% on the password test and 70% or higher on all other assignments, you will be able to print your certificate of completion. Thank you for participating in Pacific Northwest Tax School's education program. We hope you enjoyed this course.